कश्मीर पर पाकिस्तान जितनी जोर से दहाड़े मार मार कर रो रहा है, भारत और बाकी की दुनिया से पाकिस्तान को उतनी ही जोर से मार भी झेलनी पड़ रही है। क्योंकि कश्मीर से 370 हटाए जाने के भारत के आंतरिक मुद्दे पर पाकिस्तान ने कहां-कहां हाथ पैर नहीं मारे। संयुक्त राष्ट्र में तक भारत की शिकायत लेकर पहुंच गया, लेकिन फटकार उसे हर जगह से मिली। अब जब पाकिस्तान को अपनी आखिरी उम्मीद इंटरनेशनल कोर्ट ऑफ जस्टिस से है, जहां वो तथाकथित कश्मीरियों के साथ हो रही हिंसा, उन पर हो रही ज्यादतियों का अपने शब्दों में बखान करना चाहता है, तो वहां से भी उसे मुंह की ही खानी पड़ेगी, जिसकी वजह खुद पाकिस्तान के वकील ही होंगे। पाकिस्तान के वकील खावर कुरैशी कश्मीर के खराब माहौल को साबित ही नहीं कर पाएंगे। कुरैशी ने कहा कि जम्मू कश्मीर में अगर नरसंहार हो भी रहा है तो अभी उसके सबूत इकट्ठा करना काफी मुश्किल है, और अगर सबूत नहीं होंगे तो भला पाकिस्तान जम्मू कश्मीर के मसले को आईसीजे के सामने किस बिनाह पर रखेगा। इससे पहले कुलभूषण जाधव मामले में भी पाकिस्तान को अंतर्राष्ट्रीय कोर्ट में हार का सामना करना पड़ा था। आईसीजे ने भारत के पक्ष में फैसला सुनाते हुए कुलभूषण जाधव की फांसी की सजा पर रोक लगाने के साथ साथ कुलभूषण जाधव को कंसुलर एक्सेस भी दिया था। बता दें कि कश्मीर से अनुच्छेद 370 को हटाने और फिर कश्मीरियों पर हो रही ज्यादतियों की शिकायत लेकर पाकिस्तान संयुक्त राष्ट्र गया था, और वैश्विक संस्था की 15 देशों की सदस्यता वाली परिषद के ज्यादातर देशों ने मामले को द्विपक्षीय बताया था। सिर्फ चीन ने ही पाकिस्तान के साथ होने की बात कही थी। यूएनएससी अध्यक्ष ने कह दिया था कि पाकिस्तान द्वारा कश्मीर मुद्दा संयुक्त राष्ट्र में उठाने का कोई आधार नहीं है। अब पाकिस्तान के वकील ही मुद्दे को लेकर अपने हाथ खड़े कर चुके हैं। उन्हें समझ ही नहीं आ रहा कि भारत को कश्मीर के मुद्दे पर कैसे गलत साबित करें। तभी तो अब सब जगह से हाथ पैर मारने के बाद पाकिस्तान बैकफुट पर आता दिखाई दे रहा है।
Honorable Mr. President and honorable members and judges of this court, I'm grateful for the privilege of appearing in this court once again and consider myself deeply honored at this opportunity to present India's case before you in this unfortunate matter relating to the life of an innocent Indian. This case, Honorable Mr. President and members of the court, arises out of an application filed by India under Article 40, Paragraph 1 of the Statute of the Court and Article 38 of the Rules, read along with Article 1 of the Optional Protocol concerning the compulsory settlement of disputes done at Vienna on 24th April 1963. The basis for the application on which India is pursuing the reliefs which are articulated in its memorial is an egregious violation of the Vienna Convention on Consular Relations 1963, which I shall be referring to as the Vienna Convention. The case is simple. Shorn of the irrelevancies sought to be injected, there are two broad issues that arise in this case. The first issue relates to the construction of the Vienna Convention, particularly Article 36 of the Convention and its application to the facts of the case. On this, the admitted position being that consular access was not granted. If Pakistan's strange defense of exclusion of such cases is not accepted, then it has to be found that Pakistan is an egregious breach of the Vienna Convention. The second relevant issue then is the relief to be granted in this case. The Charzo factory principle of restitutio in integrum is now the settled basis for relief. The only issue is whether past precedents of this court relating to a violation of the Vienna Convention, which granted relief by way of review and reconsideration, have laid down law an inflexible rule which has to be followed in all situations. India says that the court would have to decide whether the rule can apply to military courts like the Pakistan Military Court, and whether courts that do not rise to the standards of due process can be the repository of faith of the kind this court reposed in the American criminal justice system, in Avena and Legrand. Finding itself bereft of any substantive defense, Pakistan has raised a host of issues which do not have any real relevance to these proceedings. On the issue of construction, Pakistan seeks to run one and only one defense. For diverse reasons, it suggests that despite the plain language of Article 36, it stands jettisoned when the host state alleges espionage and national security. Its submissions run counter even to the authorities it chooses to cite. Pakistan runs unmeritorious defenses under the chapeau of abuse of process, abuse of rights, of extirpe causa. It misstates the law, it misreads commentaries, it relies on material that is not recognized as having any precedential value. And finally, having failed in its propaganda against India, as a feeble attempt to counter global criticism of its role in cross-border terrorism, Pakistan seeks to raise issues such as India's refusal to allow it to indulge in a freewheeling inquiry into high functionaries without even disclosing the fundamental elements of the alleged offenses that are to be investigated and of passports that it allegedly has seized. It is India's case that none of these issues call for resolution and decision by this court. In the structure of my speech, I will first focus on the relevant issues. The relevant issues are first, the construction of the Vienna Convention. The second is applying its language to the conduct of Pakistan, which leads us to the step of deciding the appropriate relief to be granted. I will also make submissions on the evolving jurisprudence in this area of the law and of the role of Article 36 in the rubric of due process. I will then deal with defenses run by Pakistan.
A problem with the microphone.
They have gone off. Now it's come on.
Okay, go ahead.
I will resist the temptation, sir, to engage with the allegations being made as to the passport issue and the legal assistance issue beyond saying it would really be for this court to decide in the first instance whether to what extent Pakistan should be allowed to use these hearings as a platform for propaganda, without establishing the legal relevance of these wanton allegations. Pakistan is obviously embarrassed to disclose the judgment given in the Jadhav case, the specific charges against him, the evidence against him. And while the statement of the advisor on foreign affairs to the Prime Minister's office of Pakistan makes a slew of allegations against Jadhav in relation to the incidents that date back to 2014-15, the Pakistan story has always been strong on rhetoric and blurry on facts. India therefore seeks relief by way of declaring that the trial by the military court in Pakistan in the facts and circumstances hopelessly fails to satisfy even minimum standards of due process. And being violative of Article 36 of the Vienna Convention, it should be declared unlawful. Jadhav's continued custody without consular access should be declared unlawful. And amongst other things, considering the trauma to which he has been subjected for over 3 years, it would be in the interest of justice, of making human rights a reality, to direct his release. India invokes the jurisdiction of the court based on Article 36, paragraph 1 of the statute of the court and Article 1 of the optional protocol. India and Pakistan have accepted the Vienna Convention and the optional protocol without any reservations. At the hearing for the request of provisional measures, Pakistan maintained that the jurisdiction of the court is excluded by a number of reservations in the parties' declarations under Article 36, paragraph 2 of the statute. It does not pursue this in the counter memorial. The optional protocol, read with Article 36, paragraph 1, confers jurisdiction upon the court to remedy the violations of the Vienna Convention. One of the defenses raised by Pakistan is that India's failure to explore the remedy of arbitration and conciliation under Article 2 and Article 3 of the optional protocol constitutes an abuse of process. India disagrees. This court in the Tehran case has held that Article 2 and Article 3 are not preconditions for the applicability of Article 1. On the facts of this case, this defense is facially farcical. I shall first set out the facts on which India claims that a violation has been established and indicate the areas of differences in their context. Pakistan asserts that an Indian national, Mr. Kulbhushan Sudhir Jadhav, was, quote, arrested, unquote, on 3rd March 2016. This is the publicly stated position taken by Pakistan. India claims that there is evidence to suggest he was abducted and found himself in the custody of Pakistan's security forces from at least the 3rd of March 2016. A statement made by the Honorable Minister for External Affairs in Parliament in India sets out India's position in the matter, and I shall refer to it in the chronology. For maintaining simplicity in my narrative, I shall use the word arrest without accepting the lawfulness of his detention. On 25th March 2016, India was informed of this so-called arrest when the Foreign Secretary raised the matter with the Indian High Commission in Islamabad. Pakistan issued a démarche making allegations of an illegal entry of a RAW officer and his alleged involvement in subversive activities. On that very day, in 25th March 2016, India sought consular access to Jadhav. Pakistan notified the P5 states of his arrest on that very day and created a 12-page document making allegations against India. It publicly aired a video that purported to be a recording of a so-called confession by Jadhav. Some significant facts emerge from this document produced by Pakistan. It states that security forces apprehended Jadhav. It's a fair assumption that he has continued since his detention in the custody of Pakistan's security forces. The document doesn't indicate the date of his apprehension. It mentions first week of March 2016. It states that, quote, the agent has confessed, unquote. It is obvious that soon after his arrest and in the custody of security forces, the confession was extracted. Information subsequently made available by Pakistan establishes that a first information report, the acronym for which in India and in Pakistan is FIR, under the Pakistan Code of Criminal Procedure 1898, was registered as late as 8 April 2016, and that under the code marks the FIR marks the commencement of an investigation into a crime. But the confession obtained on 25th March 2016, before the FIR, was used as a propaganda measure, and its paraphrase finds place in the document circulated to the P5 countries. The document notes that this gentleman has been operating as a businessman in Chabahar. It alleges Jadhav crossed over from Iran to Baluchistan, and the document alleges he is a commander in the Indian Navy. It concludes by making serious allegations against India of state-sponsored terrorism and of repeating its efforts of 1971 in Baluchistan. You will be surprised to find, despite all this, towards the end of their counter-memorial, one of the defenses is that India has not established his nationality.